Make an opening statement because my review of the file shows that there was a final order entered in a divorce action in Montgomery County back in 2020 by Judge Closure that designated them as equal residential parents and had a 50-50 division of time. And since that time, it's my understanding there was an order of protection that was issued in this case. Is that one of the issues that we're dealing with today?
It would be, Judge, but there's also a juvenile court case that's happened since then, and jurisdiction was relinquished back to this court. That's why Mr. Parks is here. He was the guardian ad litem for the children. That was in April through December of 2024.
Right. And so what are we fighting over today?
Well, if I just may briefly, Judge, the juvenile court case dealt with some issues that were going on at Dad's home. He was married to his wife, Lacey, his former wife, Lacey, at that time. She's actually here. They divorced. There was an incident that happened with Levi. As a result of that, my client filed an emergency custody petition. That matter was heard and the children were removed from the father for a period of time. Through in December, he was granted some sort of limited visitation that wasn't every other weekend. I had that final order and then relinquished custody back to this court. Then he started having issues in his marriage. He divorced his wife. There were some concerning behavioral issues that happened with Dad. He was actually living out in the woods for a period of time. There were some things with animals that happened. He has not seen these children since December of 2024. He stopped paying child support. My client had to move to Michigan. I filed a notice of relocation with the court. He stopped paying child support. So there was an arrearage in child support, and he's not seen these children since December of 2024. These children are now 14, almost 15, and 12, almost 13 are both here and do not want to have contact with their father. They're afraid of their father. The ex-wife is here to talk about some substance abuse issues and some concerning behavioral issues. And we would ask that there is no contact with the father.
Space.
It's my client's position that mother has continuously and systematically used the system in Montgomery County and in Stewart County to limit my client's contact with these minor children to get what she wants, which is ultimately to move to Michigan to be with her boyfriend. And that's what she's done. She's accomplished that. And quite honestly, them now coming and saying they've had no contact with their father since December of 2024, they've been coached to say these things. It's my client's position. He needs to have a way back to continue to get contact with them, to be able to foster a relationship with them. Mother clearly doesn't want it. I think that the next step would probably be for mother to isolate father even further from these children so that her husband, when she marries, can then adopt the children and completely cut father out of the situation. Yes, he went through some issues. We'll address those issues in the testimony that he's going to provide today, but there's no reason that this order of protection should stay in effect. The allegations that were raised, I believe the order of protection was filed in early 2025. That's what's in place right now, is that order of protection.
The order of protection that was issued by Judge Brigham expired on March the 3rd of 2026. So there is no pending order of protection.
There was another one that looks like was filed by mother. There was another one that was filed March 4th of 2025.
And was there a temporary, I don't have a copy of that. Was that in general session?
Maybe. Yep, and it looks like it may be. I don't believe there's ever been a hearing on this.
Right, and this one is based upon, at least partially upon, the allegations that were involved in his prior relationship, prior marriage, in which there were animals involved.
Specifically, it says in there that there's no known harm to the children.
Right.
So again, we believe that this is mother methodically laying cases out in front of multiple courts to limit father's time. And that's what she's continuing to do. All we're looking for is a way back for these children and father to foster a relationship.
All right.
And if I may, I can pass forward the last order from the juvenile court, which set forth that father it was in April of 2025. Father had not visited with the children since December of 2024. And that's when the court relinquished jurisdiction back to this court. I think that would be helpful for
All right, we'll let you go ahead and mark that as exhibit 1 to this hearing. So that we're all clear, there is a pending appeal on the order of protection that was issued by Judge Brigham in March of 2025. And that has not yet been heard by this court or any other court. And therefore, we'll have a hearing on that order of protection. Then the other issue is the request for relocation. There is no pending petition to modify the parenting plan, if I recall correctly. Is there a?
Yes, there is. It was transferred from Montgomery County. It was filed in Montgomery County and they transferred it to. I have the order transferring it to Stewart.
Well, I've seen the order transferring.
All right, guys. Today we are stepping into a courtroom where things escalate fast from the very first seconds. What begins as a routine reference to an old custody order quickly turns into a storm of serious allegations. The mother's side lays out a deeply concerning narrative, claims of instability, absence, and fear from the children themselves. You can feel the weight shift as the courtroom realizes this isn't just about custody anymore, it's about safety and trust. By the end of the segment, the stakes are crystal clear, a complete cutoff is being requested, and that sets the tone for everything that follows.
Here's the petition that was filed back in November of 2024, Judge.
Okay. Maybe what I missed.
Sorry. I just assumed they sent it down. I'm assuming if you didn't have the petition, you don't have Ms. Bates' answer that she filed on February 15th. After I filed a motion for default.
I'm looking. I don't see the first thing that's in this court file is a notice of filing in June of 2025, the notice of the motion or the notice to relocate. I do have the order transferring it, with the order transferring it signed by Judge Alita. And it basically transferred the entire file, but I'm not seeing, and maybe it's out of order, is your petition for modification.
It was based on the things that happened with juvenile court and him not seeing the children and things of that nature.
Step off. I just want to make sure we've got it in the correct order. So I'm gonna, would you look to see if your file has this information in it, with the notice of appeal on that one? Let's take a short recess and let her, I want to make sure the file is reflecting what we're fighting over today. All right, let me say this to the parties, Ms. Wyman and Mr. Blue. This case originated, as you both know, in Montgomery County and was transferred over here by an order of Judge Alita. And normally that's not a problem, except for the fact that they didn't transfer the entire file. Therefore, I do not have in our file a petition to modify the parenting plan that was originally adopted. And I cannot rule on matters that are not properly before me because my jurisdiction extends to what's in our court file, not what's in another county's file. So as a result of that, I necessarily have to continue your hearing. I don't really want to do that, but I don't really have any choice. And as a result of that, the next available date that I have, and I've gone over it with your lawyers, is my next regular chancery day, which is August 4th. Now that's a long way away. In my opinion, in this case, there needs to be the reappointment of the guardian ad litem that was appointed in juvenile court. So I'm going to reappoint Mr. Charles Parks, who was here this morning, to be the guardian ad litem in this court as well. In addition to that, you've got teenage daughters, and while they are expressing a preference regarding that, it is not a simple thing for this court to simply say that a father can no longer see his children, period. Although there may be issues that have arisen in the past, there are instances where there have been abuse of children, and we still are required to allow the children to have some sort of therapeutic visitation with the minor, with them. Ms. Wyman, if you'll stop what you're doing so you can listen to what I'm saying. It's very important for two things.
Buckle up, guys, because this is where the other side pushes back hard and flips the narrative. The father's defense doesn't just deny the claims, it accuses the mother of orchestrating the entire situation to erase him from his children's lives. Allegations of coaching, manipulation, and long-term strategy come into play, turning this into a battle of credibility. At the same time, confusion around legal orders and filings adds another layer of tension. You're no longer just watching a custody dispute, you're watching two completely different realities collide, and the court is stuck trying to untangle them.
One, the children need to understand that the law says Mr. Blue has a right as a father to see his children. Termination of the parental rights is one of the most important and significant things that can occur in a courtroom. We had that this morning, and it requires a finding by clear and convincing evidence, which is the highest standard for evidence, that it's in the best interest of the minor children to terminate the father's rights. So under these circumstances, there are issues clearly, and that he's not seen the children, allegations about parental alienation and so forth. To identify what the issues are between you and your daughters, and to try to protect their best interest, as well as balancing that against your right as a father, I'm going to order that these children be, that there begin some sort of therapeutic counseling between you and your daughters and a therapist. Dr. Charles Ehrig, I think both of your lawyers are, Ehrig may be the right way to pronounce it. He is an expert witness in many cases in this court. Both of your lawyers are familiar with him. If the girls live in Michigan, then there should be an ability to do a telehealth type of a situation where they can do that by Zoom if necessary, and that will allow him to make an assessment. But in order for me to make an informed decision regarding what's in the best interest of your daughters, I need some expert testimony regarding what is in their best interest from a person who deals with this on a regular basis. Dr. Ehrig's responsibility will be to talk with the children, determine what is in their best interest, and then make that recommendation to this court. So as a result of that, this court is of the opinion that there should be an order down ordering that the therapeutic visitation or therapeutic counseling, it will not be visitation, but therapeutic counseling with Dr. Ehrig and the parents can all be arranged. Now, what that necessarily means is that your daughters are going to be involved in talking to Dr. Ehrig. So as a result of that, it is a difficult balance you strike not to talk about this case with the children. The main thing we don't want to do is to give any ammunition to Mr. Blue that says that the children are being influenced. And there are subtle ways to influence children, but I think under these circumstances, we just need to have a rule that the children will not be involved in any discussions about this case, other than the fact that this is what the court has ordered regarding Dr. Ehrig's counseling. That is a mandatory thing that they're going to have to enroll in. But beyond that, talking to the kids about what their preferences are and so forth, then we'll get to that eventually. And we have a guardian ad litem. Let the guardian ad litem speak for the children and let them communicate with him so that he's fully informed as to what their position is. That's his whole purpose, is to determine what's in the best interest of the children. But putting the children in the middle and asking them to pick or choose or trying to influence them just makes things more difficult for them, in my opinion. So we're going to try to protect them the best we can from having to be exposed to that. Under these circumstances, I'm sorry I cannot go forward with it today, but I do believe that this is in the best interest of the children to do that. So anything else before we adjourn?
With Dr. Ehrig, I've also had a lot of experience with his reports. He does like non-self-reporting type situations where he speaks to other individuals, such as both parents and other individuals to get a background with regard, he does Rule 35 evaluations with regard to mental health evaluations. And we think that's critical in this particular case, that as part of this, we look into Mr. Blue's mental health.
All right, guys, just when you think the court might move toward a decision, everything hits an unexpected wall. Missing documents, incomplete transfers, and procedural gaps bring the entire case to a halt. It's a reminder that in court, even the most emotional disputes are bound by strict legal structure. The judge has no choice but to pause proceedings, and that frustration is evident. What stands out here is how quickly momentum can collapse, not because the conflict isn't serious, but because the system itself isn't fully in place to handle it yet.
There's been no Rule 35 request that's been filed, so you would have to file a motion for a Rule 35 evaluation for me to make a determination. Again, I can't rule on something that's not before me, but I understand the basis for your saying that, and I understand the reasons why you would suggest that. And clearly, based on the orders of protection that I've reviewed and the information that was supplied, there is an issue. So, if Mr. Blue is serious about seeing his children, he might want to address some of those situations, either with Dr. Ihrig or someone else, so that there can be some evidence as to what he's dealt with. There is clearly a pattern in teenage boys, for example, who abuse animals, that can lead to more serious crimes, including sexual or violent tendencies. A lot of serial killers started out killing animals and abusing animals as a result of that. So let's get that, taken care of. But I do not have an order. I do not have a motion for Rule 35 evaluation, which would be court ordered. But Mr. Blue, if he's willing to try to help the court in making a determination regarding his children, obviously it would be in his best interest to try to address that issue. All right. Then this matter will be reset for August the 4th. And Ms. Turner, you're the moving party. I'm going to ask you to draw an order that reflects what I've been.
I will do that, Judge.
Yes, ma'am.
The children are here today. Father has not seen them since December of 2024. He would just like the opportunity to say hello to them.
The daughter's, it's a daughter and a son. The daughter is crying. No, she does not want to talk to him today.
If the son is here, any contact he can have with these children.
Contact Mr. Parks, who is now the guardian ad litem. Tell him what the situation is, see if he can talk with the children to determine whether or not they're willing to do it. Forcing teenage kids who don't want to do something to do it may be counterproductive for Mr. Blue. But they need to know that he would like to see them and like to have an opportunity to talk with them. So I think that Mr. Parks is here in town and could come back over and talk to the kids and then why don't, before you leave, since you were going to be here most of the morning anyway, before you leave, let's see if you can't get something worked out. Maybe Mr. Blue can just say hello to them if anything, but I think they do need to know he wants to see them. It is a difficult thing for a child to process, in this court's opinion, that when they haven't seen someone, one of their parents for a long time, they don't necessarily understand why that has happened. And oftentimes they will think it's because that parent does not care about them. So letting them know that he does care enough to wants to see them would be, in my opinion, something that would be beneficial to the children. Whether they then say they want to see him or not, at least let them know that he wants to see them. All right, we stand adjourned.
Buckle up, guys, because this final stretch shifts from legal chaos to raw human reality. The judge steps in with a firm, almost sobering perspective, reminding everyone that cutting off a parent is no simple decision, no matter the allegations. Therapy is ordered, rights are reinforced, and the focus turns to what's truly best for the children. But then comes the emotional. The daughter is crying, unwilling to even speak to her father. In that moment, the case stops being about arguments and becomes about damage that's already been done. It's a powerful, uneasy ending that lingers.